at it. But you're not going to sit here and disparage that man. It is not going to happen. I'm done. Bond revoked. Thank you.
Thank you, Your Honor.
Yeah. Thank you, sir. Appreciate your wait and patience online.
No problem, Your Honor. Are you still on the record?
This case is pure courtroom chaos from the jump. Judge Simpson isn't here to play, and before we even hit the 1-minute mark, you'll see him throw down boundaries that set the entire tone for the hearing. We're about to witness the people versus Larry Lee, and this one spirals into shocking accusations of extortion, witness tampering, and a full-blown legal mess. Imagine a defendant trying to leverage another case to silence testimony. Sounds like something out of a legal thriller, right? But it's real. And the way the defense scrambles, the prosecutor pushes back, and Judge Simpson cuts through the noise will keep you locked in. Pay close attention to the tension between attorneys, because every word carries weight here. And ask yourself, where's the line between negotiation and criminal tampering? That's exactly what this courtroom is about to dissect.
But I can't. Can we get Mr. Lee out? No, oh, is he? Okay. Right. Court does call the case of the people versus Larry Lee.
Good afternoon, Your Honor. Assistant Prosecuting Attorney on behalf of the people.
I forgot to wait a second.
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom.
I'm sorry?
Oh, there you are.
Good afternoon, Your Honor. May it please this honorable court, Joseph Arabo, on behalf of Stephen Kwasny.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Robles sent me, as well as Mr. Burgess and law enforcement as of this morning.
All right. And that portion of the phone call, as the court is to understand, is basically this defendant speaking with, is it directly with the victim in this case?
No.
No, Your Honor.
Attorney.
It's with Mr. Arabo, who's the attorney for the victim.
All right. And basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
This is where the legal stakes explode. The judge makes it crystal clear what's on the table isn't some casual phone chat. It's a defendant allegedly dangling testimony, like a bargaining chip. That's witness tampering, plain and simple, if proven. Think about it. Justice collapses. If testimony can be traded away, the defense wants to soften it, calling it negotiation or miscommunication. But prosecutors see a darker strategy, silencing voices that matter. This moment forces the audience to confront a brutal truth in court. Words aren't just talk, they're weapons, and Judge Simpson isn't blind to that. Question for you. If someone tried to bargain testimony in exchange for silence, do you see that as smart legal strategy or outright manipulation of justice? Drop your thoughts in the comments.
That is how I would characterize it, Your Honor. If Mr. Arabo has additional information or different information, he's welcome to.
Yes. Mr.
Yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me. And then once I realized what this was, which is an attempt to extort, and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time. I was quick enough to get on my computer and record it so that the court is aware of what's going on in the matter where I represent Mr. Kwasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length.
Here's where things get spicy. Attorney Joseph Arabo drops the word extort, That's not just a casual accusation. It's explosive in a courtroom. Extortion means using threats or pressure to extract something of value. And in a legal setting, that's career-ending if it sticks. Notice how fast the defense pushes back, saying, not extortion, just confusion. But prosecutors frame it as calculated, Mr. Lee setting up cases against victims to create bargaining chips. That's a bold, dangerous claim. Think about the strategy here. If jurors eventually hear this, extortion plants a heavy bias in their minds. Defense attorneys know it, prosecutors know it, and the judge absolutely knows it. That's why this back and forth is more than semantics. It's the battle for how the jury will one day see this phone call.
About the purpose of the phone call. I also listened to the portion of the phone call. Perhaps the court could listen to it. I do not believe that that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me is that he and Mr. Burgess have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what he has called, not being a lawyer, using the words a settlement agreement or a plea negotiation. That's what he said to me. And that he had the feeling that Mr. Burgess had not, in fact, made this phone call. So he then called this attorney, and right in the phone call,
Because it would have been unethical for Mr. Burgess to try to call to try to say my client won't testify in this other matter.
Of course.
If that, right? That's
Well,
what Mr. Burgess may not have done.
and that may very well be, but Mr. Lee indicates that, and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
That would be irrelevant.
I know that, but Judge, trust me, I know that, but I just wanted
Your Honor,
to
if I
make
may.
a record. What, can I just finish though?
Let her finish.
Mr. Lee
Sure.
indicated the main purpose of the phone call was for him to find out whether this attorney could verify whether Mr. Burgess called him. If you listen to the call, the portion of this call, it's literally on there. He says, it starts out with him saying something about plea agreements. It's the call, it's interrupted. And I believe because counsel didn't realize he was going to need to record this. But anyway, it starts out with him, Mr. Lee, saying something about plea agreement, settlement agreement. Was there any, did Mr. Burgess call you to try to, see if maybe if I wouldn't testify and then your client wouldn't testify? Yes, he says that. But then he goes on to say, because my lawyer said he called you, and then this attorney confirms what Mr. Lee was trying to find out. And this attorney says, no. You see how easy it was to reach me. I didn't talk to anybody named Burgess. That's what he says. So I'm just indicating that Mr. Lee states that was the main purpose of his call, because he claims he wanted to come in here today.
Here the defense shifts gears, painting Lee as a frustrated client rather than a manipulator. They argue he just wanted clarity. Was his lawyer lying about making calls? If true, that shows mistrust, not crime. But here's the twist. Intent matters more than frustration. Even if Lee thought he was chasing the truth, if his actions crossed into pressuring witnesses, that's tampering. The law doesn't excuse "I was just frustrated." This is where legal nuance shines. Was this call a desperate client move or a calculated scheme? Question for you. If you were the judge, would you buy the just frustration defense or see it as deliberate manipulation?
And tell Your Honor that he did not want to have Mr. Burgess represent him anymore because he feels Mr. Burgess is lying to him. I'm just representing to you what Mr. Lee has told me.
Your Honor, if I may.
I'd like to say
Yes.
something.
Thank you. Mr. Arabo, it's my turn. One moment. Your Honor.
Because apparently that's how it works in this courtroom. Tana says it's her turn, so it's her turn. Go ahead, Miss Tana.
Mr. Arabo had some trouble with dropping.
That's only because she's there and I'm not.
Your Honor, I don't really, quite frankly, care what's going on with the client relationship with Mr. Burgess, or claims Mr. Rob was making about extortion, that's not something that people are going to get involved in at this stage. What I'm concerned about is there is a clear difference between a plea negotiation and two witnesses not testifying, one of them being Mr. Lee, the other one being Mr. Quadley, not testifying in exchange for something. And I agree that the court should just listen to the call rather than us going around calling it different things. What's clear to me is that there is an offer to not testify in exchange for Mr. Quadley not testifying in this case before this court. That is what I'm hearing on that call.
Boom, here comes the prosecution hammer. The assistant prosecutor lays it out clean. Lee offered not to testify if the other side stayed silent. That's a quid pro quo. Legal Latin for this, for that. And in criminal law, that's poison. Witnesses are expected to tell the truth, not trade it like currency. Judge Simpson doesn't even need to stretch here. The recording speaks louder than any spin. Prosecutors know juries hate backroom deals, so they hammer that narrative early. This is the kind of detail that transforms a messy case into a conviction.
That is what's concerning to people, and that's what may bring future charges. We're in an early stages. This needs to go to law enforcement. If it has gone to law enforcement now, and we can follow up.
Mr. Rubble.
Your Honor, as you know, I'm a defense attorney. I think it's Ms. Rubio is really grasping at straws here to try to help her client. But here's what it is. It's not a plea. We heard her say plea. A plea means a reduction to something other than what he's being charged with, not a dismissal, which is clearly being indicated in this. Second, what's happened here is you could see clearly there has been a subsequent case filed. I don't know how to slip between the cracks because in over 10 years of practicing, I've never seen something like this where a victim turns into a defendant. What? During a pending case. Never seen anything like this. So Mr. Lee has done this intentionally so that he can one day use it as leverage to contact me or have somebody else contact me or whoever is representing Mr. Quasny so that he could use it as a negotiation tactic. And what he's engaged in is third-party communication to get through to Mr. Quasny in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion. Let's find something else. It is witness tampering. He's trying to tamper with Mr. Quasny.
This is the turning point. Forget the word extortion. Arabo rebrands the act as witness tampering, a charge easier to prove and equally devastating. Think of it like shifting from a heavyweight punch to a precision strike. The defense may argue, no threats, no extortion, but tampering doesn't need threats. It just needs intent to interfere. That's why Arabo's framing is genius. It locks the behavior into a legal box the judge cannot ignore. If the audience didn't see the danger before, now it's undeniable.
Using the leverage that he created, and I don't know if the prosecutor's office allowed this to happen. Somebody wasn't monitoring things properly, but this is what's happened. First ever time I've ever seen anything like this, and it needs to be handled. It needs to be handled. It's going to be handled.
Okay.
Can we listen to the call?
Everybody
Yes,
listen to it already.
Can somebody send it to Ms. Weidling and I will then be more than happy to listen, or if there's an easier way for me to do it, I'll do it. Let's take the defendant back and
Okay.
court listen to the call. I can give my decision.
You have to go back.
To you. I'll handle that coming back out. I think Miss Atkins on that. So bring me that. Court's going to stand in recess. Everybody can remain seated. Bring me. Pardon? Yeah. Yeah. Bring those two back, and then I'll
He would like Miss Tana and Ruli on the Burns matter. Already called.
Then I got this here. Now I got Kennedy Brown. And got it.
Yeah.
Court does recall the case of the People's State of Michigan versus Larry Lee.
Good afternoon, Your Honor. Marie Tan, Assistant Prosecuting Attorney on behalf of the people.
And Mary Rubio on behalf of Mr. Lee, who is approaching.
Get your name, please.
Clearly.
Okay. The issue is in this case that, first of all, we're adjourning the hearing.
I believe we are. That was what I thought we were doing in the beginning.
Well, it's got to stay before me. So,
I know Mr. Burgess is already going to be here on July 1st. I just wanted to put that out there.
yes, but I'm not on the,
Oh,
I'm on the bench, but I'm not doing these.
okay.
So. Set his preliminary examination July to defendant's request. So my next date is July 22nd, 2025. And that's another 12 p.m. start because God, I love that. All right. With reference to bond in this case, I've listened to the recording. I'm not going to say there's an over exaggeration or an under exaggeration. I mean, I think it's relatively clear when somebody's very clearly points out an exchange or quid pro quo regarding me not testifying and this other person not testifying, and that is the exchange.
Judge Simpson finally speaks his mind, and it's damning. He says it outright. The call shows a quid pro quo, a direct attempt to obstruct justice. Judges rarely speak this bluntly, unless the evidence leaves them no wiggle room. Notice how he points out the defendant bypassed his attorney. That's a red flag for manipulation. Once the judge frames it as tampering, the case tilts hard against Lee. This is why judges matter so much. They cut through lawyer spin and call things for what they are.
I don't know that you get a clearer indication of somebody that is attempting, and especially when they circumvent their attorney, of somebody trying to sort of tamper with and obstruct a case. It couldn't be clearer. I mean, and quite frankly, I don't think there's any design to necessarily frost it over or anything along those lines. I think the idea or what Mr. Lee is saying about what Mr. Burgess wouldn't do is quite frankly just a ruse to hide his own desire to have the exchange that he was speaking with counsel about. Given that, and the court having heard that, with reference to this case, the defendant's bond is hereby ordered revoked.
This is the gut punch. Judge Simpson doesn't just slap a warning, he revokes Lee's bond and even strips his phone privileges. That's huge. Revoking bond means Lee sits in jail until trial, a major shift in leverage. Why? Because the judge doesn't trust him anymore. When a judge loses trust, defendants lose freedom. Watching this moment is like watching a door slam shut. Lee's defense team loses bargaining power, and prosecutors gain all the momentum. If you've ever wondered how one phone call can destroy a defense strategy, this is it.
Based upon the court's hearing of that bond violation.
Your Honor, can I just raise two issues? Before all of this happened, Mr. Lee expressed to me and attempted to express to the court his, as I'm sure the court has gleaned, his displeasure with Mr. Burgess. So I do think given some of Mr. Lee's allegations against Mr. Burgess, it may be best if someone else is appointed to the case. I know he doesn't want Mr. Burgess.
And that's fine. I don't know whether or not he doesn't want Mr. Burgess or not, because I think, as I'm indicating, I think that notion of Mr. Burgess not doing something and then his checking is simply a ruse for him to try to get the message that I want this quid pro quo, this exchange.
And I'm not accusing Mr. Burgess of anything. I'm just trying to represent what Mr.
No,
Lee has
and
told
I
me.
understand that.
And Mr. Lee is
I think
about
when
jumping
you-
out of his skin trying to talk, just so you know.
And so when you talk to Mr. Burgess, if Mr. Burgess, if he believes that that's the appropriate step, he can bring that motion before this court and the court will hear it in
Okay.
the day that I'm on. Mr. Lee, I will let you talk in a moment, but I'm going to finish this. Revoking your bond because of what is a clear violation of the bond regarding, I mean, I think it's an attempt to try to get indirect contact as well as obstruct these proceedings. Because that was accomplished in the manner it was, and I'm not sure that I can trust you with reference to no context and the like, we're at least going to get through this. I am going to, subject to a hearing, defendant's phone privileges for the jail are also revoked. What did you wish to say, sir?
The thing that my substitute attorney here didn't convey to you was that I told her that I have the evidence with me in hand, that my attorney, Mr. Burgess, was the one that actually said that this was a legal way that we can go about it. And no, I'm not.
You know what, Mr.
not-
You might as well stop right now.
I have the text.
Because no, I'm going to tell you, I don't know if you're misunderstanding something or what, but you are not. Mr. Burgess has appeared before this court. You are not going to sit here and try to disparage that man, saying that somehow or another, Mr. Burgess represented to you that obstructing a case in this fashion was a legal way to proceed. I'm not going to believe it, and I'm not going to hear you. I'm not going to hear you. I don't know what how do you not understand what I'm telling you? Now, if you've got that information and you think that's what it says, you get it to counsel and the court will take a look at it. But you're not going to sit here and disparage that man. It is not going to happen. I'm done. Bond revoked. Thank you.
Thank you, Your Honor.
Thank you, sir. Appreciate your wait and patience online.
No problem, Your Honor. Are you still on the record?
And that seals it. Judge Simpson shuts it down with authority, revokes bond, and refuses to let the defense smear Mr. Burgess in a last-ditch attempt to deflect blame. The lesson? Courtroom strategy is a razor's edge. What looks like a smart play outside can collapse into tampering, obstruction, and jail time inside. This case showed us how fragile attorney-client trust is, how prosecutors seize on words, and how quickly a judge will crush misconduct. Lee thought he could blur the lines between negotiation and manipulation. Instead, he exposed himself to harsher consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.